Members, we turn now to the Evidence Amendment Bill. The question is that Part 1 stand part. The Honourable David Parker.
Thank you, Mr. Chairman. I would like to make my first contribution in respect of the Minister's supplementary order paper, which amends Clause 26 of the bill. Clause 26 of the bill, the supplementary order paper makes three changes. I'm not going to talk about the changes to Clause 16 or Clauses 35A. They seem pretty clear and uncontentious. I do want to just check that my understanding is right in respect of Clause 26.2, which inserts a new Section 90 subsection 7 into the Evidence Act, and this concerns previous consistent statements of a witness. Now, it's a bit confusing to follow because the original provisions don't lie in Section 90 of the original Evidence Act 2006. They appear to sit in Section 35.3 of the Evidence Act, which concerns previous statements of a witness that are consistent with the witness's evidence, and they're admissible currently if circumstances relating to the statement provide reasonable assurance that the statement's reliable and the statement provides the court with information that the witness is unable to recall. Now, it seems that the Law Commission recommended that that part of Section 35 was moved to what is going to be new Section 90 through this Clause 26. But the recommendation from the Select Committee that came back was that this admissibility of a prior consistent statement be limited to allowing the witness to refresh his or her memory rather than the previous consistent statement of the witness being admissible in evidence as of right in those circumstances. And I'm just a little confused how this change works, given that the two subclauses after that still apply, which are, if you could just forgive me, sir, the subclauses which are in the existing Clause 26.2, inserting the new subsection 7, the two conditions are in A and B and say that the circumstances relating to the statement provide reasonable assurance that the statement's reliable, and the statement provides the court with information that the witness is unable to recall. So if the previous statement is to be admissible now, it's going to be admissible not just to refresh the memory of the witness, but effectively evidence in its own right, which is now going to be there, even if having their memory refreshed, the witness cannot remember it. And I wonder if the explanatory note is right to say that that is what the Law Commission actually recommended, because that's what the explanatory note says. That was to say that the Law Commission recommended, or they say this reflects the original policy intent to amend Section 90 in line with the Law Commission's recommendation to move the substance of that Section 35.3 to Section 90. So that's my first question for the Minister. My next question, sir, relates to the what's being done in respect of business records. The bill quite rightly fixes a problem identified with the Evidence Act, which is that the admissibility of business records wasn't quite right. So the definition in Section 16 of the Evidence Act, which deals with a business record, is amended, and in amending it, it makes it clear that a business record that is a hearsay document that can be admitted as evidence of its contents cannot include a police record that contains any statement or interview by or with an eyewitness or a complainant or any other person who purports to have knowledge or information about the circumstances of the alleged offending or the issues in dispute in a civil proceeding. It's a longer definition than the original amendment that came to Select Committee, Mr. Chairman.
The Honourable David Parker.
Which was that does not include a police record that contains any statement or interview by or with an eyewitness or a victim. So it's been extended in the way that was in the longer form that I read it out. Now, Mr. Speaker, that seems to me to be sensible, and therefore I am speaking in support of that amendment that has been made at Select Committee, because the normal rule against hearsay, which is being abrogated in respect of business records, should not be abrogated in respect of a police record of a statement or interview by an eyewitness or a complainant or any other person who purports to have knowledge. So, Mr. Speaker, I think that the Select Committee change there is useful, and the Labour Party will be supported. I think, my understanding of the earlier matter that I referred to in terms of the new form of clause 26.2, inserting the new section 97 is correct, that we'll be supporting that too, but I just want to check that I have got that right. I want to now turn to Jan Logie's supplementary order paper, which is about the ways in which evidence can be given by complainants in criminal proceedings that are cases, sexual cases or concern domestic violence. Now, the bill already makes some good improvements to the way in which child witnesses can give evidence in similar cases, and that is achieved in section 107 of, the new proposed section 107 of the Evidence Act inserted by clause 32 of this bill. Jan Logie is proposing an extension of that to the ways in which complainants can give evidence, even if they are not child witnesses. Now, I'm aware that the Law Commission has done work in respect of this. I think it's unfortunate that some of the earlier work that was done by the Law Commission in this regard was, I think, rejected by the prior Minister Judith Collins, and that, I think, is why Jan Logie is trying to do this by way of her supplementary order paper. Now, sir, we know that the number of successful prosecutions in respect of crimes of sexual violence and domestic violence that isn't sexual is the rate of conviction is very low, very, very low. And one of the reasons for that is that complainants are reluctant to give evidence. And one of the ways that as a society we can improve the experience of complainants is through these more, shall I say, protected ways of giving evidence, perhaps by video or perhaps behind a screen. And that, I agree, is completely appropriate in respect of child witnesses, and I think it's probably appropriate in respect of complainants too. And indeed, I think that subsequent recommendations or responses from the department to some of the Law Commission's earlier recommendations might see this coming forward as government legislation in a future bill. And we'd be willing to consider that then if this supplementary order paper doesn't get up. But I think the reason that Jan Logie is bringing this forward is because she's frustrated that the Prime Minister, not the current Minister that's sitting in the chair, had pulled that out. And so I'll be interested to hear from the Minister as to whether the government will be supporting Jan Logie's supplementary order paper, which I think's got number 195 at the top, and it's about clause 32 inserting after the new section 107B, this new 107C that she proposes, and some related documents. It is quite complex. There are other cross-references in the Act that you've got to get right to make these things right. I hope that
Order.
it can be considered.
Order. I might just be able to help the member. It appears that no supplementary order paper has been received from the member, Jan Logie. There was a proposal, but it's no longer being tabled.
I picked this up off the table, sir.
Well, maybe we can seek further clarification.
Well,
to the clarification we've already had.
well, okay, thank you, sir. I'll accept that clarification.
Maybe it should have been taken off the table.
Yeah, well, that makes it easier because it is actually quite a complex thing to do way of supplementary order paper. So I can congratulate Jan Logies for efforts that she obviously put into this, but maybe she came to the conclusion that it was actually better to leave to a process, because one of the points that I was going to make is that it may be that some submitters on the legislation hadn't properly considered that in their submissions, and it might be better to improve that area of the law in a later bill.
In light of select committee changes that were made. Right,
okay, thank you, Mr Chairman. In terms of the bill...
Mr Chair.
I call the Honourable Amy Adams.
Mr Chair.